All right. Well, good evening. Thank you for joining us for our family engagement series. Tonight, we will be exploring part one, which is our parent rights and procedural safeguards. I'm excited to have everyone who's with us this evening, and we'll go ahead and get started. Like I said, if there's any thing that you need to stop me on or get further clarification on, feel free to either raise your hand in the the chat box or just hop on. I'm a pretty informal person and don't need to have specific time for questions and answers. My name is Stephen Moran. I'm a consultant with State Support Team 11. I do predominantly most of my work is in special education, but also with family engagement in our community outreach. Things that we do, as well as school improvement, are my main areas. So there's my contact information on the front page. At any time, if you feel you need to reach out and contact somebody to get further clarification on something, advice, stuck in a dead end, don't know where to go, please contact the SST. I'm typically the one that handles the parent questions. If I'm not available, somebody else will definitely step up and be able to help you. All right, so state support team. So a lot of parents, first question they ask, what is the state support team? So first, we are a level of support that the state Department of Education has created, a tiered level of support at the state and regional level. We would be considered the regional level for that. We cover Delaware, Franklin, Fairfield, Licking, Madison, Pickaway, and Union counties, as well as Chillicothe. So that is our area. We work closely with the Department of Education, Office for Exceptional Children, specifically Office of Early Learning and School Readiness, and Office of Improvement and Innovation. So those are pretty much the three biggest buckets of our work there that we do, but we also have some outside things that we also cover. We are located at the Educational Service Center of Central Ohio, which is on City Gate Drive over by the airport, pretty much between the airport and Easton Town Center. What do we do? So state support team staffs partners with local districts, agencies, and organizations to implement effective internal and external processes to best meet the needs of all students. We also work, a lot with Children's Hospital, their behavioral health unit down there, their rehabilitation units, things like that, as well as other, outpatient places, therapies, centers, things like that across the region. And like I said before, the biggest areas are school improvement, special ed, early learning, and family and community engagement. State support team staff works to support the efforts of the local schools' plans, implementation of those plans, and monitors their school improvement work, their goals, and their initiatives. Some services we provide: internal, external systems, data analysis, implementation checks, professional development for teachers, practitioners, family, and parents, obviously, surrogate parent training, legal training through Bricker and Eckler attorneys for special education administrators, principals, superintendents. We do consult with parents in special education's procedures, supports, and services. We're not, if you call and ask a question, we're going to give you what the law says. We can't speak, specifically to what district policies are. But obviously the law is something that is universal throughout all of our districts in Ohio. On-site district monitoring, which is where the Department of Education will go into a district and they will basically audit their special education programs. Involved in that would be record, they look at ETRs and IEPs, as well as implementation of services in classrooms and other compliance related areas. Consult with our districts on curriculum, special education, PBIS, which is that positive behavior interventions and support, social emotional learning, literacy, and school improvement. We also partner with the Dispute Resolutions Office at the Department of Education. If there is a complaint that is made by a parent or whomever, the Department of Education will ask us to help either train staff or help complete activities around fixing what that corrective action is for the complaint. We also have a series of networks that we do with school district staff around career technology, post-secondary transition. We partner with Ohioans, Opportunities for Ohioans with Disabilities, parent mentor groups, Ohio Coalition for the Education of Children with Disabilities, and OCALI, just to name a few. And OCALI is the Center for Autism and Low Incidence, which is down in Worthington. The target objectives today, we want to outline the major components of a guide to parent rights in special education, as well as debunk or clarify any myths or misunderstandings that you may have, and answer any questions parents, families, and guardians may have throughout the presentation. Does anybody have any questions about what we do at the SST, State Support Team? A lot of times that is the biggest question we get is from parents. They call and they say, hey, what do you guys do? So I just wanted to start this whole series out by just kind of giving a brief overview of that, some of our work. Everybody, if you're a parent in this group and you have a child who has been identified with a disability and receives special education services, or if you have ever been through the process or are an educator, you should be very familiar with this document here. I think Julie has hers right in front of her. So there you go. Julie's modeling for us. The Guide to Parent Rights in Special Education. This applies to students for grades or ages 3 through 21 and is guided by state and federal requirements. The federal requirements are referred to, you'll hear and see reference to as IDEA, and the state requirements are going to come from the Ohio Operating Standards for the Education of Children with Disabilities. After today, this presentation will be available in the folder, the link that you received, so you will be able to refer back to it as well as pull some of the links. I also included a link to the Ohio Operating Standards, which is about 175-page document. The great thing about it is if you download it on your computer, you will be able to hit Control F and search for certain things. So if you have a question about, transition, post-secondary transition, you can type that into the search bar and then it'll take you to any page where the word that is mentioned. The document itself otherwise doesn't really follow a really easy, understandable flow. So you kind of got to look around for certain things. If you have that document in front of you outlining what those laws may be and ever have any questions, you can call us at any time. We will help you at that point. A note about the Ohio Operating Standards: they are under current review and could change at some point during the school year or summer. Typically what happens is the Department of Education will present that to the board. The board will do their due diligence and say, yes, let's move this forward. At that point, it then has to be reviewed by, they have a couple, JCAR is one of them, as well as SAPEC, which is just advisory groups, and that, will question certain things or talk about how they apply to certain laws. There's also a public comment period that when it is released, there will be a public comment period that you can go on and you can review things. Where we sit right now, I'm not even totally sure what those changes are going to be, if any. I just know they're looking to better align that with federal law. So to help eliminate some confusion here in Ohio, hopefully. Just a little background about IDEA, the Individuals with Disabilities Education Act, that protects the rights of students with disabilities and the rights of their parents. This guide, the Guide to Parents' Rights, tells you about those rights. The school must give you a copy of the guide once every year. If your child receives special education services, you also must receive a copy if you ask your child to be evaluated because you think they may have a disability. If your school district wants to have your child evaluated because they think your child may have a disability, if you file or submit a complaint in writing, or if you submit a request in writing with the Office for Exceptional Children about a due process hearing, And lastly, if your child has been removed from school for disciplinary behavior reasons and your child has already been removed from school for 10 days or more during the current school year. So instead of like continuously passing this document out, passing it out, there's typically a disclaimer like within the IEP document that, you know, so-and-so was offered the parental rights document. They have declined to take it at this time. However, the document is available on the district website at whatever address. A lot of districts have gone digital with these things. But you must be offered it by the district at all times. Most of the time, if the district knows that, you know, parents have been through the process before, they're not going to like, you know, hunt you down and try to get you the document, but they just assume you have it at that point. What's available in the document. So here's just a picture of the table of contents, just a brief overview if you don't have that document in front of you. General information on educational records, the dispute resolution process. That's a big one, a big process there. We'll get a little bit into that. Discipline, placement for children with disabilities by parents in private school at public expense, and then parent notification of scholarships, programs for students with disabilities. The first thing that I wanted to make sure we discussed was informed parental consent. So informed parental consent means that you and or the district appointed surrogate parent give permission in writing. And that's the key there, is that in writing part for the school district to take an action. Your permission also means the district gave you information about the proposed action. Your child's school district must get this permission from you in writing to do certain things related to your child's special education. The school district must get written permission for the following things: before the district evaluates your child for the first time to see if they qualify for special education and related services, before they start giving your child special education services, which is outlined in that IEP or individualized education program, before the district reevaluates your child for special education. So once they qualify every 2 years, well, 3 years minus a day, they must reevaluate your child or student to make sure that they still qualify. Before they conduct extra assessments with your child, and one example of that would be a functional behavior assessment. And then before a change of placement decision is made, change of placement is not only location, but also programming. So keep that in mind. And then before the district gives information about your child to someone other than those listed on in the state or federal law. And then it's not required when the district is reviewing existing information as part of the evaluation process, or the district conducts assessments with your child that are administered to all students. So if every sixth grader in the school gets the career passport interest inventory test, you're not going to receive a consent form. But if they are looking to do some transition planning with your student specifically, and they want to give some assessments, then you will receive a form for consent. Does anybody have any questions about that informed parental consent? All right, we'll keep moving. To give informed consent, the district must make sure it has used native language or other understandable form of communication. So if the home language is, French or Spanish or whatever it may be, the document has to be given to them in that language. Otherwise, it's not considered in providing informed consent. Make sure the parent understands and agrees in writing for the district to carry out an activity. There's a lot of, talk and confusion this past couple years, or almost 2 years now, I guess, with COVID. Can we send emails? Can we do text messages, other form of, digital media, things like that? The department right now is telling us that informed consent still must be in writing, because that is what the precedent that the courts would look at if they were to get involved. Make sure you understand you are giving consent by your own choice, and you can change your mind at any time. So even after you give consent, if you, go back and look at a document and you think, oh no, what did I do? You can then take your consent away in writing to the district at any point in time. And you must make sure that you understand that if you withdraw consent, the district does not have to undo any action it took between the time you gave consent and when you withdrew it. Are there any questions there with consent?
Yes, I do actually. Hi.
Hello.
Hi, I am a special education director. And I'm just wondering about the going back to the consent paper. You have said have to be in a native language. What I heard was that we could explain verbally in their language, but the paper does not have to be translated. Is it true or no?
Yes and no. Like if that's brought to a court hearing, it's going to come down to like hearsay essentially. Like if you say, well, we explained it, and then the parent says, well, no, they didn't because I speak Spanish and they explained it in English, or they didn't explain it at all. That's the protection there with the written consent, is that you can't it doesn't come down to who said what. It's like hard proven evidence at that point. Okay. There are some languages that we have heard throughout our region of the state that are like almost non-translatable, or there's not anyone who can translate these languages, or people are coming from remote villages and things like that in other countries. So you have to do the best you can to provide that information. Whatever information that parent would need to provide informed consent is available to them.
Okay.
So the document itself doesn't necessarily need to be translated in that language, but the information within that document that the parent's going to need to make an informed decision does.
Oh, okay. And does ODE have some translated version of it?
I'm not sure if there's translated version there. I know there's translated versions of the Guide to Parents' Rights document, but like there's not going to be they don't have like translated versions of like the planning form for the ETR or anything like that.
Okay, thank you.
Yep. Anybody else have a question? All right, so time to evaluate. So there's different instances when evaluation can be initiated. Anybody has the right to initiate an evaluation. If you're, a caretaker of a student, or if you're a teacher that works with that student, or an administrator, and you suspect that there might be a disability, you are allowed to initiate that evaluation. As a parent, just some things to keep in mind. You're going to ask the district to evaluate your child if you think your child may have a disability that is affecting his or her education, to determine their eligibility for special education. The district may also ask if you want your child evaluated because staff members may think they need services. No matter who initiates the evaluation, just remember that the district must get consent in writing and finish the evaluation within 60 calendar days of receiving consent. So what that means is, if we'll just use like easy dates to try to remember. So like October 1st, I send home a consent form. I don't get the consent form back until November 1st. My 60-day timeline does not start until that consent at the school district is received. So it's not when the parent receives it, it's when the school district receives it back. It's important to keep in mind, if you are a school district employee, when you receive that consent, most districts, what they do is they timestamp it, kind of like the old school way, with a little stamp that like moves date and time, stamp the document right then and there. And that's when your consent begins. Keep in mind, if you're from a school district also, if the parent, dates the document October 15th, 2021, and they put it in Johnny's backpack, and Johnny doesn't turn that document in for 2 months, that the date that the school received it was not in fact the date that it was signed. So we always encourage like districts to send home send that stuff with students unless there's a situation where that student can be trusted, or communication has already been established that that document's, on its way home. But to provide, stamped envelopes that the parent can then send that right back directly to the student school when they need to do that. We have a lot of districts that do get, and I don't want to say they get in trouble because it's not really like they don't get like fined or anything like that, but that get in some hot water with those timelines because, there's certain months that don't have 30 days. So they assume that it's like 2 months from that day. There's some months that have more than 30 days, things like that. Districts are completely internally responsible for those timelines. As a parent, you also, if you ask your student's school district to evaluate them, and you get the evaluation back and you disagree with it, you are entitled to an independent educational evaluation, also known as an IEE. Keep in mind, the district is only obligated under law to consider the results of any outside evaluation as it determines eligibility or continued eligibility and how it will provide your child with a free, appropriate public education. So basically what that's saying is any parent is entitled to a independent evaluation. However, the district only has to consider those results. So if the district, evaluates your student and determines like that they are not eligible, and you as a parent disagree with that, and you say, okay, I want an outside evaluation. Outside evaluation says, well, we think that, yeah, they might be eligible in this category. The district, that does not override what the district decision is. They have to consider those results. And they will also have to submit a prior written notice to the parent that they considered those results and what their ruling finding was from those results. The district representative ultimately is going to have the last say in that conversation. Some scenarios that occur when you request an outside evaluation. So you request the district to pay for an independent evaluation. The district agrees to the request and tells you how to arrange the evaluation. So they will set the stipulations for that. Obviously, they will provide maybe a few locations and places that you can get that taken care of. Obviously, they don't want you to go to a place that is going to cost exuberant amounts of money. You already got the outside evaluation and you want the district to pay for the cost. The district pays you back for what you spent on an outside evaluation. That is also possible. The district may think an outside evaluation is not needed. They ask for due process hearing to explain why its evaluation that they conducted was appropriate. If the hearing officer decides the district evaluation at that point in time is appropriate, you can arrange for your child to have an outside evaluation and pay for it yourself. Or if the hearing officer decides that the district evaluation is not appropriate, the district will pay the cost for your child's outside evaluation. The final situation there is you already got the outside evaluation. The district files for a due process hearing to show that the evaluation did not meet district criteria. So there's some instances where parents will come into the school and say, hey, I already got an outside evaluation. Here it is. And then the district will respond with, yeah, but that doesn't meet our criteria that we set for these evaluations at that point in time. Are there any questions about independent evaluations? I get a lot of questions. I had an evaluation at the school. It said this. I took my child to a behavior specialist at Nationwide Children's Hospital, and they said that. How do I get them to integrate that into what the school is doing? That's just conversations that are, you have to have with the district. Contact the district rep or the principal and say, hey, my son or daughter had an outside evaluation. I just wanted to make you aware of the results. Please, contact me so we can arrange a meeting, things like that. Districts are not going to know that outside evaluations have been conducted all the time. And also, like as a parent, you also have an obligation to, if there is information available that could help that student in school, to make that available to the greatest extent possible to that district so they can make the best decisions for your child. Eligibility determination. Eligibility for special education and or related services, and related services are going to be like your, speech therapy, occupational therapy, Trying to think what else. Vision and hearing specialists, mobility, things like that. You have to qualify under one of these 13 categories in the state of Ohio, and to be found eligible for special education. Some states are different. Some states allow for like a primary and secondary disability category, if that's applicable. Some states don't have disability categories. It's either you're special education student or no, you're not. Ohio has made the determination that they use one of these 13 categories. And keep in mind, developmental delay is only a preschool identification. So you will not see like a student in kindergarten through 12th grade or a student who defers graduation qualify under developmental delay. They will be reevaluated when they enter what is known as school age and under one of those disability categories. Does anybody have any questions there? I'm not going to get really into what those disability categories are. Those are outlined in the operating standards. And then if you have any questions there, we can talk a different time. It's just too much to fit into our time together. This is the initial evaluation procedures flow chart. This is going to outline your timelines. Once a disability is suspected, within 30 days from the initial referral, they need to provide a PRO1. And a PRO1 is a prior written notice. And basically what that prior written notice from receiving the referral is going to say at that point is, yes, the district agrees to move forward with an evaluation for your child, or no, at this point in time, the district does not think that a disability is present. Here is provided data, or here is why we made the decision we did. The ETR, like we talked about, is held within 60 days of the initial consent, unless SLD mutually agreed to extend the timeline. So there are extenuating circumstances, but the school district and the parent have to agree on those. And then the IEP is held within 30 days of the ETR or 120 days from their referral. Copies of the PRO7 must be made available to the parent within 30 days. The PRO7 is the IEP. So within 30 days after an IEP meeting, the parent must be provided with a copy of that document or access. Some schools have online portals where that stuff is posted. But at any point in time, if you request access to that document within 30 days of a meeting, you are entitled to that as a parent. And the draft that some districts send home prior to the meeting does not count. It has to be after the meeting has been held. The prior written notice, like I talked about, that PRO1, if you are a parent that has been in special education with, and experienced it before, you're very familiar with these notes that are sent home at multiple times throughout the year. A school district must give you a written notice called a prior written notice within a reasonable amount of time before it poses or refuses to take certain actions. A lot of the time, the follow-up question there is what defines reasonable amount? We don't know, actually, to tell you the truth. Months, weeks, years, obviously years would not be considered reasonable. Typically, if it's within that 30-day period, that would be considered reasonable, is what we've been told. The prior written notice is a universal form that the Department of Education has developed. And on that note, there will be detail in the note about what educational decisions have been made for your child. And it must contain, why they decided to make the decision they did, what decisions they've rejected, what they proposed. Things like that. The prior written notice must also be provided in a language that's understandable to the general public and written in the native language or other mode of communication, unless it is clearly not practical to do so. So that kind of goes to that. Okay, if the language that is spoken at home is like from a remote island or something, it's not necessarily practical to if you can't find somebody to translate that at that point. The prior written notice includes a description of the action or proposed action by the school district. So in some situation, it was like, it will be like the district agrees to change reading goal for so-and-so because they have met their previously listed goal, or the district has agreed to get rid of the reading goal because the student has met all of their goals and is now on grade level, whatever that may be. An explanation of why the district proposes or refuses to take that action, and then a description of each evaluation procedure assessment that was used to make that decision. The statement about the parents being protected under IDEA is typically already pre-populated in that document. A description of other options the IEP team has considered. So in some instances, parents, they want like a one-on-one aid for the student. The district would respond that, we do not, the district has come to the decision that a one-on-one aid is not going to be provided. Here's why. However, we will provide a check-in place for the student twice a day. So a proposed action that would be something else the team considers, and a description of other factors relevant to their proposal or refusal. Here is what that document looks like. I put them side by side because I couldn't fit it straight up and down or side by side this way. So it's kind of off kilter here, but after other, it goes right down into this section here. So I'm sure you all have seen that. Here's the note, the written in built-in note at the bottom. You will give a copy of your procedural safeguards document once per year. In addition, given a copy under the Ohio Revised Code and things like that. The dispute resolution process. If you're concerned about the education of your child, the first step is obviously, we always encourage parents to work with school buildings. Speak to the principal. I always, always encourage you to start with the teacher and the principal at that building level, just because those are going to be the people that are going to be most closely able to speak to it. At that time, if you feel that the issue is not being resolved, obviously, you can move your way up throughout the district, special education coordinators, supervisors, whatever that may be. You're first obviously encouraged to consider the following. Start with the channels at the district level. Start with the teacher, principal, special education coordinator, and directors. And then just keep in mind that most disagreements can be solved with communicating with the right people. I get a fair amount of phone calls where a parent has an issue, and I ask, who have you talked to at the school? And they respond with nobody, or I couldn't get a hold of somebody, or so at that point in time, it's just really trying to coordinate who's the best person to get a hold of and talk to. And more times than not, those issues get resolved for the parent. Administrative review is going to be one of your first steps. If you disagree with your district's decision and no agreement can be reached, you can submit a complaint to the district's administrative office. The administrator assigned will then review it. It's typically the superintendent. Sometimes in bigger districts, they have a designee. They'll conduct an administrative review, which might include a hearing. It must be at a time and place where all involved participants have the opportunity to attend, and all involved agencies must be involved. So if a student is attending a county board of DD, obviously that agency has to be involved in that conversation. Additional processes you can try. If you've completed the administrative review and contacted the school district and you still don't agree how to resolve a problem, there are more processes to try. While you're not required to request an administrative review before moving on to other dispute resolution processes, it is encouraged. That just kind of keeps things in-house. It doesn't involve outside people that really might not be able to speak to that process. The process is in the district, and it's also going to get things done a little bit quicker.
Stephen, if you don't mind, I had a quick question about the last slide that you had.
Yes.
So I had a question about it. I, as a parent mentor, when a parent files a due process claim and they want to start the process, I am not able to assist them after that point. I have to wait until the process is finished, and then I can assist them, afterwards. Where would I, if if that happens and when that happens, where would I find information on the steps that I need to take? Because I wasn't aware of that. And it's nice knowing going forward, but I didn't know after that point, when a parent files that, I'm not able to assist them.
So what is your question? Just so I make sure I'm hearing this right.
So I guess I'm wondering where I might find information on so I know in the future, this is where it says I can't, help you after this step. Is that on an ODE website? Is that on your website? Because I see all the information here, but as far as parent mentors go, I haven't been able to find any documentation that I can point to saying, this is where this is coming from.
Okay.
And, you're talking about it briefly.
Yeah, I'm not totally sure what the requirements are like, or what a parent mentor is able to be involved in that process or not. I can do some research for you if you want to. You have my email address, don't you?
Yes, I believe I do. So
Okay.
I don't want to take up too much of your time, but just keep that in mind. And if you hear of somewhere I could go, I would appreciate it.
Okay. Yeah, I'll definitely check it. If you want to send me an email and remind me, I will do some research for you and see if I can talk to some people down at ODE about what your role would be if that does enter a due process.
Okay, thank you.
Yep, no problem. Continuing on this, obviously we say, the Department of Education Office for Exceptional Children can get involved. You can call down there. We always encourage you to, start with what's closest to you and move out. State support team, I'm biased to it. I'd like to think we're a great resource for parents and able to provide them with a lot of help and assistance they need when they call us. So please, call us as well. Local parent mentor, like Brittany said. So parent mentors, just real quick, if people don't know, parent mentors are employees of the district who are hired to help bridge the gap between the district and the parent understanding. Parent mentors, they go through, specific training. They have to have specific requirements to become a parent mentor. They're going to be able to speak specifically to helping parents asking the right questions, as well as specific processes and procedures in the district that they represent. Whereas if you call a state support team, like I said, we're just going to give you kind of like a global overview of it. The Ohio Coalition is also available for guidance, but they're up north, so they're not really, they're not going to be able to say, if you call us and say, who do I call in, Olentangy district about my son who's in 7th grade, we're probably going to be able to help you a little bit quicker there. Early complaint resolution is when you attempt to settle differences with the school district informally before you start to utilize other more formal dispute resolution options. Someone from the Department of Education Office for Exceptional Children will work with you to address your questions and concerns. ODE and the SST encourage early complaint resolution before you ask for a formal process, such as a written complaint or a due process hearing. And then there's the numbers that you can contact. Like I said, I will put this slideshow in the folder, the link that you have, that it's a folder link that's also included with the Zoom link email that you got for this. Facilitation is one step that you can take as a parent. Facilitation is when you ask the department to arrange a facilitator to attend a meeting of your child's evaluation or IEP meeting. Keep in mind, you are a member of this team. You can make that request for them to attend your child's meeting directly to the Department of Education. The district must also agree to have a facilitator present at the meeting. If the district does not agree, then obviously you would go to another step of resolution at that point. But most of the time the districts will, I've never heard of a district say, no, we're not going to do a facilitated meeting. These are kind of like the preemptive steps that you can take to avoid more formal facilitation. Why would you do facilitation? You might ask. That it's a neutral third-party person who's not a member of the team, the IEP team, so they don't represent the school district and they don't necessarily represent the parent, but they are informed to enough about the process to be able to ask questions, bridge communication gaps, things like that. You can request facilitation at any time throughout the process. Keep in mind, they are a neutral third party. They do not work for you as the parent or the district. They are a professionally trained mediator. Most instances they are, we see a lot of lawyers that are involved in that process. They've been trained and know what special education laws and requirements are. They're not formally an official member of the IEP or ETR team. They do not make decisions, but they help find solutions. And like I said, they're there to help with keep the focus of the meeting on the child and their needs, as well as help assist in conversation. Mediation would be the next step. If you still are unable to reach a resolution, mediation is when parents in the school district agree to have a third-party professional come to a meeting to help them reach an agreement about the education of that student. The third party means the person is also called the mediator. They do not take sides and do not work for or act on behalf of the parent or the district. Is a choice for parents and districts at any time there's a disagreement involving education. It is free and it can be requested at any time. OEC, the Office for Exceptional Children, will give you choices of a mediator to direct the meeting. If you and the district are unable to agree on which mediator to choose, OEC will assign one, and then that person will keep in mind the mediator cannot tell you how you must resolve the issue. Rather, their approach is to help the sides express their concerns and find a viable solution. Here's the overview of the mediation process. So the parent requests mediation, the mediator is selected, and a meeting is scheduled. There's then the mediation meeting. You and the school district share the concerns. Mediator helps settle a dispute and come to a final written agreement. Generally, nothing that is said during the mediation can be shared outside of the meeting or used in future legal proceedings unless an exception applies. The agreement is then reached. It is binding, and both the parent and the school district sign it. Binding means that the school and the parent must follow the agreement, and a court at that point in time is able to enforce it. If agreement is not reached in mediation and you file a state complaint, then the Office for Exceptional Children will resolve that complaint. If the agreement is not reached in mediation and you file for due process, then a due process hearing comes next. Key points to remember, just to see side by side. I know we kind of went through quick, but we're on a time crunch. Facilitation is voluntary. You do not have to agree with the district at the meeting or how the meeting turns out. You're always allowed to have your own opinion. Any disagreement made during facilitation is generally binding. This means that both the parent and the district have to follow the agreement after it is made. And then mediation, the mediator remains neutral. The mediator is not allowed to make decisions. They help resolve issues involving the education. They work on a written mediation agreement, which the districts will have available. They help open lines of communication. It's voluntary, it's confidential, and any written agreement is binding between the parent and school to follow the agreement after a decision is made. And filing a state level complaint. So the state level complaint can be filed within a year of the alleged violation. The parent provides the original copy of that complaint to the Department of Education and a copy to the district. The complaint alleges violations under special education requirements supported by facts. The department reviews those complaints and sends an acknowledgement letter to whoever filed that complaint, and then sends a letter letting you know that, yes, this is sufficient evidence and complaint. We will move forward, or we do not have enough at this time to proceed. Next step, the department reviews all documents and requests, anything, documentation or information that might be needed to help review that complaint. And then they also conduct interviews with individuals as needed. The department at that point will send a letter of findings to the school district about each allegation, whether it's a special education violation. The department issues then corrective action to the district based on that complaint. And that is oftentimes when the SST has to come in and provide training. So if a parent complains that, hey, my child didn't get specially designed instruction as written in their IEP. Okay, yes, the district did not provide that. Now the teachers have to go through training on how to implement specially designed instruction. That's where the SST will then step in. The due process procedures are on pages 22 through 28 of that Guide to Parent Rights document. If you need more information, I want to make sure to give time for questions here. Filing a due process complaint, one of the last way parents can resolve certain concerns about child's education is to file a due process complaint directly with the Department of Education. When you do this, when you file this complaint, also called a due process request, keep in mind there are others who can also file a complaint. Besides the parent, the student, if they're at least 18 years old, the district can also file a due process complaint, and then other public education agencies. So a district might file a complaint if a parent isn't returning a consent form to reevaluate a student, and the district is then still held to that 3-year timeline. The parent's not responding. At that point, they can file a due process themselves. Information to include in your due process hearing. It's on a department form. You can Google that or use the search bar on the department's website for the due process complaint form. And that's just the information you would have to enter in. If you ever get to that point, I hope you don't, the more detailed you are, the better. Discipline. In some cases, your school district may have to continue providing special education to a student after they've been suspended or expelled or otherwise moved from their current educational placement. If the child is removed from current educational placement for fewer than 10 days, consecutive days, the district does not have to provide your child special education services. So that would be like if they get suspended for 2 days or 3 days or whatever. If the child is removed for more than 10 days, consecutive days, the school district must continue to provide special education services, even if it's in another educational setting. That would be a situation where if a student gets suspended or expelled, that district still has obligation to provide special education services. Sometimes they have that student come in after hours. Sometimes they have, like, school districts will have home instruction teachers that will go to the student's home, things like that. That's agreed upon by the team. If the district removes a child from current placement for more than 10 consecutive school days in the same year, it is considered a change of placement. You must have an IEP team meeting at that point in time. And if the district has removed your child from his or her current educational setting on separate occasions that add up to more than 10 days, the district must determine if those removals constitute a change of placement. So that would be if a student gets suspended like on multiple occasions, 2 days here, 3 days there, 4 days there. There was a question in the chat box: can a due process be filed without going through other steps before asking for facilitation or mediation? Yes, that you can do that at that point in time, at any point in time. Okay. The district factors to consider in that discipline: the length of time the child was removed, how close together the removals were, the total amount of time they were removed, and similarity of the child's behavior for which they were removed. So if the child's constantly getting removed from the setting, from school for insubordination or violence or fighting or things like that, they will look at patterns in this behavior. Manifestation determination. Before changing your child's education placement for disciplinary reason, the school must take specific steps. There's a meeting with a manifestation determination meeting to determine if the child's behavior had a direct and substantial relationship to a child's disability. So that would be like a student with a cognitive disability who is maybe suspended for fighting. You bring into the conversation, okay, the student has a cognitive disability. Are they truly able to understand that fighting is not appropriate behavior, or are there other factors that need to be considered, that maybe they're nonverbal and that's the only way they know how to react, things like that. So it's not like a one size fits all situation. All the factors and things in the IEP and that student's educational plan and programming would be considered. At the meeting, the members of the team review relevant information, such as teacher information, their IEP, and whatever else may be provided. The child, if the behavior is a manifestation of your child's disability, so that's the team then agrees that, yes, the behavior was a result of the student's disability, the child will be returned to placement from which they were removed unless the team agrees to a change of placement at that time. Change of placement at that time might be like a student with emotional disturbance who lashed out. Yes, they lashed out because they have an emotional disturbance, but maybe the school, the public school with a class of 20 kids is not appropriate. But hey, there's a learning center or a classroom in the school that can, with less kids that has more structure, things like that. If your child's behavior is found to be a manifestation of the disability, the team must start a functional behavior assessment within 10 days and complete it as soon as possible. They must begin a behavior intervention plan for that student. And if a behavior intervention plan already exists, review the plan and make changes. All right, that leaves us about 6 minutes for questions. I know this was kind of a quick run through. We just wanted to have a forum, a format that's available to parents to ask questions, get some information that might, if it sparks more questions, great. If you got the information you needed tonight, even better, but we are always available to talk. Email is the best way to reach me. Currently, we have kind of we're out in districts a lot and outside meetings and things like that. So I'm not always at my work phone, but my email is always connected to me. So that is my email address and my phone number right there for you. Here's our mailing address. We don't really get a lot of mail anymore, obviously, with email, but we want to provide that in case people, we do have people stop by sometimes, not likely, or, with COVID and things like that it happens, but if you need to, and there's our just general mailbox at the SST. So if you can't get a hold of me, sometimes June, July, August, people are out. If you can't get a hold of an individual consultant, if you send it to that mailbox, it is monitored and somebody will respond to you. We are on Facebook, Twitter, and SoundCloud. On SoundCloud, there are podcasts available. It is a new project we started last year. There's anything ranging from how to connect with schools with families to I'm trying to think what else we have. Post-secondary transition podcast, podcasts about diversity, equity, and inclusion. There's just a variety of things that you might find interesting. And then if you are into Twitter, we post daily resources, links, further training opportunities, and things like that. And like I said, I will put this PowerPoint in that folder that you have the link to. If for some reason you can't find that link, just email me and I'll send you the PowerPoint directly.
Can I ask a question on the manifest
Sure.
meeting? Is that meeting, can that be part of a regular IEP review, or is that something that has to happen after the 10 days of suspension or emergency removal?
Yeah, that's kind of a two-part question. So it happens outside of the IEP meeting. So you can't really have it before, you can't have it before that 10 days is reached, because then you're considered predetermining, you're like assuming that the student is going to reach that number. Does that make sense? So you can't have it. So you can't have it at day 8 or 9, because then you're making the assumption that, okay, that student's going to get suspended again. So it's considered predetermination. So it won't be until you reach that 10-day time. And then emergency removal is like a totally different, that's a totally different conversation, because there's districts that are using like emergency removal in lieu of suspension, so they don't ever get to those 10 days, but those days actually do count towards that 10 days because you're removing the student from their educational setting. So they still do count.
Okay. And then the personal situation I'm in, I get the sense the district doesn't really want to work with the high needs of my child. So they're not, they're having to emergency remove him. They're potentially changing the location of his placement, but it's still within a resource room setting. So that's really not changing placement, right? But you said
Yeah,
programming.
well, placement is not necessarily just like a place. It's also like the programming around it. So if they're in a resource room that has, or if they're in a classroom that has 20 students in it, and then, okay, now we're going to put them in a resource room, but the resource room, it's obviously still in the same school. You're still changing that placement for that student.
But if I go from a resource room with 5 kids versus a resource room with 3 kids in the same school.
Yeah, you're changing the placement, but like on the surface, it doesn't really change any. It doesn't change like the classroom structure. So you're considered a resource room. Once more than 50% of the students in the classroom are special education identified with IEP, it's considered a special education classroom. There are no like numbers for a resource room. So like you could have 5 kids, you could have 25 kids. If there's 13 of those 25 are identified with IEPs, and it's considered a special education classroom.
Okay. And if they still find that the situation's not working, are they required to continue to educate the child, or can they pass the buck, so to speak, and say, no, we